and to what extent law is an affair of rules. Now let's pick each of these. At least the first question I will briefly summarize, because that is something that you have discussed in your first semester. And how does law differ from, and how is it related to orders backed by threats? Now, if you remember jurisprudence 1, there was a very long discussion on how Hart has a problem with Austin's theory of law as a command backed by sanction. And he sort of says that law need not always be in the form of command backed by sanction. There can be law. Law can also be formulated in different manners, and for that specific purpose he draws a distinction between two concepts called having an obligation and being obliged to. And if you remember, there was a discussion on the gunman theory, wherein let's assume that a gunman is pointing a gun at A. Now, Austin's theory of law as a command of sovereign backed by sanction means that any command given by a sovereign, and provided that there is a sanction being defined by Austin as an evil consequence, automatically would convert that entire scenario into a law. Now, what Austin says is that there is a difference between being obliged, what Hart says is that there is a difference between being obliged to and having an obligation. According to Hart, law is about having an obligation. Law is not about being obliged to do something. In a gunman situation, therefore, what he argues is that because gunman threatens, let's say, A with adverse serious physical harm, in case A does not hand over the money to gunman, A is coerced into handing over the money to gunman and therefore is obliged to act in a specific manner in response to the command of the gunman. However, let's assume that we change the threat of the gunman, and what the gunman threatened A with is merely a pinch on the arm. Now, in that scenario, A would not specifically be obliged to hand over the money to the gunman. Now, that means that A per se does not have an obligation to hand over the money. A is being obliged to hand over the money because of a specific situation which is operating. And if you change the nature of threat or coercion, A would not be obliged to hand over the money. Now, similarly, what he also argues in order to bring out or draw the difference between being obliged to and having an obligation is that law is not always about, therefore, being obliged to do something. Law is about having an obligation to do something. Therefore, and if you remember, there was an example that he gave that, let's say a person is mandated to report on time for once that person is elected to join the army of a specific country. And in the absence of reporting on time, there would be severe penalties which would be conferred on that individual. Now, let's say the person did not attempt or did not join that specific position on time. In that scenario, we can very clearly say that the person was not obliged to act in a particular manner. Like in the gunman situation, where in this situation also there was a threat, there was a coercion, but an individual was not obliged to act in a specific manner. But nevertheless, irrespective of the fact that the individual did not find oneself obliged to act in a particular manner and escaped, the person did have an obligation to act in a specific manner. And therefore, what Hart says is, law is not about being obliged to do something, because when we are obliged to do something, we necessarily act in a specific manner. Law is about having an obligation to do something, irrespective of whether you translate that obligation into an act or not. Now, this is one of the critiques that Hart had proposed when he was discussing Austin's imperative theory of law as command and command-backed sanction. And thereafter, subsequently, he builds on his theories and argues that law is a union of primary rules and secondary rules. Primary rules being obligation-conferring rules that create obligations, and secondary rules being three kinds of secondary rules which he came up with. Those three rules being rules of recognition, rule of change, and rule of adjudication. All these three rules of secondary rules had very specific purposes. Rule of recognition, the rule of recognition was to recognize which of these primary rules, because there can be several kinds of obligation, but all obligation need not translate into legal obligation. And Hart has already discussed something which you all have already discussed, that how an obligation enforcing rule is recognized as a legal obligation. Now, the rule of recognition is very simple, to recognize which of the several obligation imposing rules can be recognized as legal obligations. Now, the rule of change is basically to bring about a change in the rules, that is the secondary rules, that for example, rules of amendments, rules of repeal, etc. can be put into the category of rules of change. And the third important secondary rule which Hart talks about is rule of adjudication. Now, rule of adjudication according to Hart was basically in order to allow or to cure the defect of inefficiency of law and allow the law to be implemented in a specific manner. So rules of adjudication would, for example, account for several rules like procedural rules, the manner in which adjudicatory processes happen, etc., etc. Now, these are the three secondary rules that Hart talks about, and according to Hart, law is a union of primary and secondary rule. Now, that was the Hart's main formulation of what law is. And this is the manner in which he answered the first recurrent question regarding law, that how does law differ from and how is it related to orders backed by threats. So according to Hart, law need not always come with some kind of sanction or evil consequence, sanction defined as evil consequence by Austin. Rather, law is a union of primary and secondary rules. Now, pursuant to this discussion, and this is something that we will be discussing in our course this semester, is that what the second recurrent question that Hart poses before you in the beginning of his book, that how does legal obligation differ from and how is it related to moral obligation. Now, the first question that he poses in order to answer this question is that, is there in fact a necessary connection between law and morality? And do law and morality have a necessary connection such that when you talk of law, you have to inadvertently always necessarily talk of morality? Now, those who argue for a relationship, and those school of thoughts and thinkers who argue for a relationship between law and morality, seem to have consensus with Hart at least on one ground, that ground being that the simple imperative theory, and by simple imperative theory means those theories which consider law as command. And the propounders of imperative theory are obviously Bentham and Austin. Though both Austin and Bentham differ in the manner how they formulate law as command, but both Austin and Bentham are talking of law as commands in one sense or the other. Now, what Hart says in the initial stage of the chapter is that there seems to be a consensus between Hart and all those thinkers who try to provide a connection between law and morality, or think that law is necessarily linked with morality. And that consensus being very limited, and that limited consensus being that the simple imperative theory, that is the theory that formulates law as command, is inadequate. And Hart's theory, that is law is a union of primary and secondary rule, is definitely an advancement and a better version of definition of law. So the consensus between Hart and those who think that there is a necessary connection between law and morality seems to be the fact that imperative theory, simple imperative theory, which formulates law as a command, is inefficient to cover all the dimensions of law. But according to those who not Hart, but others who sort of argue for a relationship between law and moral, what they also argue for is that you cannot understand or expound on this concept of law until and unless you necessarily develop a relationship between law and moral. Now, what we will see Hart doing in the subsequent part of chapter 8 is define morality or try to explain what he understands by morality. Now, when he is saying, now there is sort of a graded argument being made with respect to what is the connection between law and morality, and it is an entire spectrum of argument. But Hart, in the very initial stages, is quoting the extreme version of the argument, which is taken by which is made by Thomas Aquinas, and Thomas Aquinas being a natural law philosopher. Now, as we had studied, and we had studied in Spellinger Explorer case also, natural law theorists generally consider law and morality to have some necessary connection, that there is a necessary connection between law and morality. Now, Hart is taking or citing the example of Thomas Aquinas, and interestingly he says that the reason why he is citing Thomas Aquinas is because among all the arguments that are made citing a necessary connection between law and morality, Aquinas takes the extremist view. The extreme view being that if a law is not just, if a law is unjust, it is no law at all. Now there are two different contentions which are made by those who follow the Thomas Aquinas tradition of natural law, who are known as Thomists. The first contention being that there are certain principles of morality or justice which are discoverable by human reason. And when we say that there are certain basic principles of morality or justice discoverable by human reason, we end up saying that those principles of morality or justice are universal in nature because they are discoverable by human reason itself. So there is a kind of universality to the morality that Thomas Aquinas talks about, arguing for a universal kind of morality or justice which is only discoverable with human reason without the aid of any divine revelation. And the second being that any man-made law which conflicts with such universal principles of morality or justice discoverable by human reason are not valid law. So, arguing for that morality, if understood in a Thomist sense, would render a law to be invalid. So, a law has to necessarily conform to the morality, to the idea of morality, and that is what the that is what Thomists who lie on the extreme end of the spectrum of thinkers who argue for a necessary connection between law and morality argues for. So the question started with whether there is a necessary connection. Okay, please feel free to interject me in between in case you find a difficulty in understanding, because I understand it is a bit complicated concept that we are discussing. But I'm just trying to put before you all the important arguments that were raised by Hart in this chapter, and then we can open the floor for questions and you can give in your responses. But please feel free to interject in between. So I was saying that the question that Hart, and the second recurrent question that we are discussing in chapter 8, that is there a necessary connection between law and moral. So first, Hart is trying to invoke all those who draw a necessary connection between law and morality. And he says that for example, Thomas Aquinas considers any law which is in violation with the principle of morality to be an unjust law. And there is also a Latin maxim for that, lex injusta non est lex, meaning an unjust law is no law at all. But he also concedes to the fact that this is not the only position which is taken by those thinkers who consider that there is a necessary connection between law and moral. There are several other positions which are taken by thinkers who though confirm that there is a necessary connection between law and moral, but do not take an extreme view as taken by Thomas Aquinas. Now, for those who are not taking those extreme versions, those thinkers consider morality not per se as universal or immutable principles of conduct, but as expressions of human attitude which may vary from society to society. So the Thomas tradition of natural law considers morality to be universal in nature, but there are also, just so that you are aware of that, there are also, and Hart tries to clarify his position that he knows that there are also traditions of natural law or traditions wherein among thinkers who consider that there is a necessary connection between law and morality, wherein no universality is given to the idea of morality, and it is understood that morality may differ from society to society and from individual to individual. Now, having said so and having laid down the background to the discussion between law and morality, Hart sort of identifies two issues. And he says that in order to understand whether there is in fact a necessary link between law and morality, we need to identify and separate two issues. One being, is there any distinction between specific idea of justice and special features which account for its peculiarly intimate connection with law? So, what is justice? What is the specific idea of justice, and how justice is related or connected with law? Now, what we will see Hart doing subsequently is he's trying to sort of distinguish between two terminologies here before he comes to drawing the necessary linkage or not a linkage between connection between law and morality. He is trying to first unravel what is the meaning of the term justice and whether justice and morality are interchangeable terms, or are they different? Are there certain distinctive marks that distinguish justice from morality? Now, what he said is that, therefore, the first issue that he has flagged in his writing is that there needs to be we need to distinguish or understand the specific idea of justice. And what is the connection of... okay, is my voice breaking? Fine, I assume it is not, so I'll continue. Okay, thank you. Yes.
A little bit.
Okay. I hope I'm audible now. So, what he says is that the first question that is flagged here is that whether there is a connection between law and justice itself, and what is it? The second question that he is flagging is what is the characteristics which distinguish moral rules from legal rules, as well as other form of social rules or standards of conduct. So what is the difference between moral rules, social rules, and legal rules? So let's pick up the first issue that he has flagged in his chapter, that being, what is it that he means by idea of justice? Okay, what is the specific idea of justice, and what is the relationship between this concept of justice, idea of justice, and law? Now, so I will first give the conclusion, what Hart concludes, and then I will bring up the argument. Though Hart in his chapter has proceeded in the reverse manner, he is giving his argument first and concluding subsequently. Hart considers morality to be a genus and justice to be a species. So justice is nothing, according to Hart, but a segment or subset of morality. Justice need not always be cannot always be interchangeably used with morality, according to Hart. Morality is much wider than the concept of justice, and he gives several arguments in order to elucidate this point. As to why justice and morality are not one and the same thing, and they cannot be interchangeably used. So the first argument that he is giving is, and he gives this a rather interesting example when he says that how do we use the term just or unjust, and differentiates the usage of term just and unjust from the usage of term good, wrong or right, or good or bad. Now, what he's saying is that, and an example that he gives is that, let's assume a man who is guilty of gross cruelty to his child. Now, a man who is guilty of gross cruelty of child would be accused of doing something morally wrong, morally bad, or morally wicked. Or he may also be accused of not conforming to his moral obligation or not complying with his moral obligation. But according to him, it would be sort of weird if we call this gross cruelty of man to his child, the man to be, that specific act to be unjust. Now, the reason why he's saying is that because the closest term that comes to just or unjust is not wrong or bad, but fair or unfair. Now, how does he distinguish between something which is wrong or bad from something which is just or unjust, or something which is unjust from something which is per se wrong or bad? And he sort of gives two characteristic features to this point, and these two characteristic features are the feature of distribution and the feature of compensation. So what he says that what would be just or unjust what would be unjust would if a man had several children and he would have given differential treatment to different children. That would perhaps be unjust. But a man being cruel to a child per se cannot be said to be unjust. It can only be considered to be wrong, bad, or wicked. So what he's arguing is that when we are criticizing something, or if we criticize something or critique something as just or unjust, we are basically making there is a very specific connotation to that criticism, and the closest word that comes to just or unjust is fair and unfair. Now, and then subsequently what he is arguing is that fairness need not always be considered moral or immoral. So it is not interchangeable with morality. And he says that there are just two situations in social life wherein we can invoke fairness or unfairness, or this terminology fairness and unfairness. And please remember, Hart considers just and unjust to be sort of interchangeable with this word fair and unfair. And what he says is that the first instance where we invoke this idea of fairness or unfairness is where we are concerned with how the burdens or benefits are distributed among individuals. So, according to Hart, something would be unfair and therefore unjust if the distribution of burden and benefit is uneven or unequal. If there is uneven distribution of burden and benefit, that is something which would be considered unjust or unfair. And that takes us to the example that Hart gave previously, and which I quoted, that according to Hart, a man being cruel to his child per se was not unjust, but if a man had different children and he was according different treatment to all those children, that is something which would be considered to be unjust. That means that the benefits were being distributed unevenly and in a differential manner. The second, so that's what he's saying is that therefore what is, and this is exactly, I'm exactly quoting Hart, he's saying what is typically fair or unfair is a share. And a share of what? A share of benefit or burden. So every individual, according to Hart, and if you have to understand how Hart is defining the concept of justice, just as fair as what is typical as an even distribution of burdens or benefits among different individuals. Now, the second characteristic feature of this idea of fairness, or let's say this concept of justice according to Hart, what is justice, that when some injury is done on someone, a compensation or redress is claimed. So according to Hart, we talk about justice or fairness, and please remember Hart in his writing he has used justice and fairness interchangeably. We are talking primarily about distributions, that is distribution of benefit and burden, and compensation, that is compensation of any injury suffered. That is how Hart primarily defines this concept of justice or fairness. And I have already told you that justice is not interchangeable with morality, but according to Hart, justice is definitely interchangeable with this concept of fairness. But Hart does concede that that distribution and compensation are not just the two only manner in which you define whether something is just or unjust. There are several other things that may be described as just or unjust. For example, he gives that a trial may be described as just or unjust, a judge may be described as just or unjust, a person may be justly or unjustly convicted. Now what he however says that all these different aspects, manners in which we use the terminology just or fair is merely a derivative of the primary manner in which we use the term just or fair. And the primary meaning of justice or fairness is that justice and fairness talks about two important concepts. One is distribution, that is distribution of benefits and burdens, and the second is compensation for any injury suffered. And that is the main primary manner in which Hart understands the concept of justice or fairness. Now, having said so, what Hart subsequently argues as in furtherance of the argument that he is giving and in furtherance of how he is defining this concept of justice, what he argues is therefore justice translates into equality or into maintaining or restoring balance or proportion. That the status quo must be maintained, right? That there must be equal treatment and there must be some balance or proportion restored. Now, this may not seem very clear here, but Hart invokes a very common a phrase that we often use, especially when even today we use when we are dealing with this principle of equality, that is treat like cases alike and treat different cases differently. So what does this term treat like cases alike and treat different cases differently means is that there must be some proportion or balance in which we are distributing benefits and burdens. And if there is any kind of imbalance in the distribution of benefits and burdens, then it would amount to the occurrence of an injury and a compensation can be claimed for the same. And that is what justice is according to Hart. Now, however, again, there are too many howevers with Hart, and because Hart has taken almost all the viewpoints into consideration and has been very clever about addressing all the different kinds of critiques or the different kinds of possibilities or critiques that can be made against his statement. And that is why this is something that Hart had said about Austin and Holmes and Dworkin had said about Hart. That though Hart may be wrong clearly, but even when he was wrong clearly, he was clearly wrong. So there is a sort of clarity in the manner which Hart has enunciated this entire discussion and given his arguments on this relationship between law and morality. Now, what he says is that, therefore, that though I understand that like cases, so if justice translates into equality, which eventually translates into maintaining or restoring balance or proportion, what we can, if we had to put it down in a phrase, the closest a phrase can come to this idea of justice is treat like cases alike and treat different cases differently. Something that we which also invoke when we are discussing Article 14 of the Constitution or when we are discussing right to equality in general. Now, however, what he understands is that there are how do we come to the conclusion or decision that something is alike and something is different is a question that we have to answer first. So what is important is that this entire idea of justice also is extremely complex, and it has two parts. One is a constant part and one is a shifting or varying part of this idea of justice. And when I say idea of justice, I mean Hart's idea of justice, wherein he considers justice as equality and justice as justice in terms of distribution and compensation, justice as equality and something which the aim of which is to maintain or restore balance of proportion. Now, what he says is that this entire structure of justice that Hart has just propounded has two parts, one being the uniform part or the constant part, and one being the variable part. The uniform or the constant part is treat like cases alike and treat different cases differently. Okay. So, what is the shifting or the variable aspect of this structure of justice? The shifting or variable aspect is that what are the criteria that you will invoke in order to consider what is alike and what is different. Now, for example, the example that he is giving is, for example, we might express ourselves by saying that a tall child is the same height as a short man, but both of them have the same height. But a man having, let's say, a man of 6 foot height and a child of 6 foot height, the manner in which we address them would be different. Man would be, the child would be addressed as a tall child. Now, what we are doing here is that there are different criteria which are invoked in understanding what are the criteria that we are invoking in understanding what is alike and what is different. Now, there are two very famous decisions which sort of can be considered an example of the scenario which Hart is laying before us, of United States Supreme Court, that is Plessy versus Ferguson and Brown versus Board Education. Now, in Plessy versus Ferguson, which was a decision given by US Supreme Court in 1896, racially separate facilities of same quality were considered to be not a violation of right to equality and not a violation of constitution. So, in Plessy versus Ferguson, for example, blacks and whites blacks were only allowed to travel in specific railway carriages, and whites were allowed to travel in specific railway carriages, and there was segregation practiced in railway carriages. But the quality of facility that was given in both the carriages were equal and same. But what the court said was that this is not an example of like cases being treated in a different manner or unlike. These are example of like cases being treated likes, because blacks and whites cannot be treated on the same pedestal. They are not like. So, because they are not same and equal, they cannot be treated in the same and equal manner. So, that's why segregation was considered as a policy. The name of the case is Plessy versus Ferguson. Now, however, this judgment was subsequently in 1954 overruled in Brown versus Board Education, where racial segregation in public school was considered to be a violation of constitution, wherein it was said that Plessy versus Ferguson came up with this concept of separate but equal, but Brown versus Board Education said that being separate is not equal. So, two individuals cannot be distinguished on the basis of the color of their skin, and color of the skin cannot be a criterion for differentiating between two individuals. Now, this is exactly what Hart is referring to, that there is a constant variable which we are talking about when we are talking about this idea of justice, and there is a shifting variable. The constant variable being treating like cases alike, but the shifting variable being what are the criteria that you are invoking to consider who all are alike and who all are different. Now, what Hart says is that we have come to a conclusion, and generally what we see is that considerations of race, color of the skin, etc. are generally not considered to be considerations to differentiate between individuals. That is what Hart is saying. And even in those situations where those considerations are invoked, at least lip service is paid to the idea that we are not in fact invoking those considerations of race or caste. Race, religion, and even caste. And we are not invoking all these categories to differentiate between different individuals. But nevertheless, what Hart argues definitely is that there is definitely a sort of a constant variable in this idea of justice and a shifting variable in this idea of justice. Now, what Hart says subsequently is that the resemblance and difference between human arrangement which are relevant for criticizing legal arrangement as just or unjust are therefore most of the time quite obvious. For example, invoking race, invoking gender, invoking caste, invoking religion for discriminating between individuals is an obvious criteria for criticizing a law or a legal arrangement to be just or unjust. But what we need to understand is that there are two kinds of critiques that we make when we are talking about justice and injustice. One is whether one argument or the one manner in which we can criticize a law for being just or unjust is that the law itself is not unjust, but the administration of law is unjust. So per se the law is not unjust, but the manner in which law is applied is unjust. So what we say, what we would say is that the formulation of law itself is not unjust, and therefore the law itself is not problematic, but the application of law itself is problematic. And the second form of criticism that we make against law is that it is not just the administration of law or the implementation of law that is unjust, but rather the law itself which is unjust. So he gives, and what he is citing is, for example, and he cites the example of this natural justice rule, that is the principle of audi altrum partem. And what he says is that audi altrum partem is a rule which in itself may not be unjust, but the administration of that rule may be unjust when someone is not rightly heard. And therefore he draws a distinction between the justness and unjustness of the law itself, and justice and injustice or unjustness of the administration of law. Now, so till now, what Hart has tried to do is, first of all, argue that justice and morality are distinct terms, and justice is nothing but a subset of morality. Justice primarily can be translated, the primary characteristic features of this idea of justice being distribution and compensation, which can be roughly translated into the idea of equality, wherein the aim of justice is to restore balance or proportionality. And subsequently, what Hart says is that there are two different aspects of justice. One is the uniform or the constant part of justice, and the other is the shifting or the variable part of the justice. Now, what he is subsequently saying is that every demand of justice requires that equal treatment must be overridden in order to preserve something of a greater value which would be jeopardized if discriminations weren't made. Now, what is the meaning of this statement? What he is trying to say is that there are different moral considerations that would guide our understanding of justice. And he gives a very interesting example of barbarians and Greeks, and he says that what is in in a society where the morality of the society dictates that barbarians and Greeks are unequally placed, such that any assault by a Greek on a barbarian goes unpunished, but an assault by a barbarian on a Greek would definitely be punished. In such a society, in a society that is built around such morality, where the morality of the society itself is based on an uneven treatment of the barbarians and the Greeks, the justness or the unjustness of the law would be determined in a society governed by such a morality on the basis of this morality. So in such a society, morality, if we were guided by morality, and the morality would determine what is justice and what is injustice, in such a society, the law that provides equal treatment to barbarians and the Greeks would be considered to be unjust. Now, this is one of the criticisms, and that is how he is trying to draw a distinction between justice and morality by saying that what we understand is that the manner in, if we understand justice as something in the form of equal treatment being provided, or there being in the form of distribution, or in the form of distributive, in the form of equal distribution of benefits and burden, in the form of restoring the status quo, then it is important that we also understand that moral considerations would, and in a specific morality and in a specific moral considerations would determine what is just or what is unjust. Now, what he subsequently says is that that this idea of justice, when we are talking about saying that like cases may be treated alike and unlike cases may be treated unlike, need not always mean that classifications cannot be made between individuals. So first he is saying that there are certain classifications which are very obvious on the face of it to be unjust classification, for example, and according to him those classifications being matters of color or race. But there are certain classifications which are not. For example, in contract law we have this classification between minor and major. Sane individual entering into a contract and insane individual entering into a contract. Now, all these classifications are legitimate classifications or are legitimized in law, and such classifications are not automatically considered to be unjust classification. For example, when we are studying constitutional law, we consider these such classification to be based on intelligible differentia. If a classification is based on intelligible differentia, it per se is not a violation of right to equality. And if we take Hart's argument, bring in Hart's argument here and try to draw a connection between the two, what we can say is that what Hart is trying to say that a rational basis of classification would allow rational based criteria can be invoked to determine who all are like individuals and who all are unlike individuals. Now, thereafter, what he says is that there are, when we are talking about, and I will just sort of read this specific paragraph which is on page 164, that the connection between justice and injustice of compensation for injury and the principle treat like cases alike and different cases differently lies in the fact that outside the law there is a moral conviction that those with whom the law is considered have a right to mutual forbearance from certain kinds of harmful conduct. Such a structure of reciprocal rights and obligations prescribing at least the grossest sort of harm constitutes the basis, though not the whole, of morality of every social group. Its effect is to create among individuals a moral and in sense an artificial equality to offset the inequalities of nature. Now, what he is saying is that when we are drawing a connection between justice and injustice for, let's say, compensation of injury, which is one of the aspects of justice which Hart talks about, it is based on the fact that there is a prevalent belief that and a moral conviction that individuals will prevent themselves from harming another individual, or individuals will not indulge in any kind of a harmful conduct, and therefore and in such a conduct, what the effect of such a conduct would be that it would create among individuals a moral equality. And when he is talking about moral equality, he is using artificial equality in the same line as moral equality. So what he says is, its effect is to create among individuals a moral and, in a sense, an artificial equalities to offset the equalities of nature. So what he's saying is, and this is in continuance with his idea that different criterions may be invoked to determine what is like and what is unlike, and those different criteria may be guided by the prevailing morality to determine what is like and what is unlike. Now, and again, the example that I gave you, that this differential treatment of barbarians and Greeks. Now, in a moral order where barbarians and Greeks are treated differently, or the moral outlook being that barbarians and Greeks are treated differently, when we are critiquing law, we would say that a law that treats barbarians and Greeks in a same manner is unjust, and it can only be just if it reflects the difference that the morality of that specific time and society talks about. That is the morality of differentiating between the barbarians and the Greeks. Now, this brings us to the next aspect of how he understands, of how Hart understands morality. And what he says is that many times there are many situations, therefore, so if we understand justice, now let us just quickly recap what we have discussed till now. If we understand justice as something that distributes burden and benefit, something that compensates for the injury caused, something that tries to restore the status quo, in that scenario, what we will find is that there are several instances where we sort of sacrifice this principle of justice for some other principle, wherein like cases are not treated alike. Okay, because many times what we find is that such demands of justice which talk about, and justice as understood by Hart, that is restoring the balance, restoring the balance and proportionate treatment of individual, proportionate treatment of individual. What Hart says is that many times what we find in law is that such principles of justice are sacrificed, and they are sacrificed for some other principles. They conflict with other values and principles, and they are many times sacrificed as well. For example, for principles of general security or welfare of society. So, for example, he cites the example of strict liability. Now, strict liability is something that we study both in strict liability offences we study in IPC, and the idea of strict liability is also taught in torts, where you must have studied Rallens versus Fletcher, when it said that if you store something, if you store a hazardous substance on your property and that hazardous substance escapes, then you would be liable even if you were not responsible for causing that escape. The strict liability offence was taken one step ahead in India in the oleum gas leak case, wherein we came up with absolute liability, saying that absolutely no defense is allowed. Even if a hazardous substance escapes, then the person storing or the individual storing the hazardous substance is absolutely liable. Now, these no-fault liabilities or strict liability do not take into account the concept of fault, and when we discuss strict liability offence in IPC, they don't take into account the concept of mens rea. That means that while for all other offences, individuals are mens rea is taken into consideration or fault is taken into consideration. For strict liability, fault is not taken into consideration or mens rea is not taken into consideration. Now, what is it that allows sacrifice of this principle in favor of sacrifice of this principle of mens rea or let's say false liability in favor of strict liability offences or strict liability torts. Because going by the principle of justice, if like cases are to be treated alike, all individuals must be held responsible, liable only if some fault can be proved on their part. Now, what he says is that generally the argument or the justification that we give is that strict liability is, for example, strict liability torts or strict liability offences are permissible because there is when we are talking about strict liability or strict liability, we are talking about an implicit appeal to the general welfare of the society. So, in favor of general welfare, we many times allow the sacrifice of this concept of justice, which talks about treating like cases alike, because the idea of justice that like cases must be treated alike is many times sacrificed for some other value. So, and it is at this point that Hart tries to draw a connection between the concept of justice and the concept of social good or welfare. And he started with this idea of justice as restoring balance of proportionality. But is there a connection between idea of justice as well as this concept of social good or welfare as well? Now, what he says is that when there are different alternatives available, many times one alternative is considered to be a proper alternative because that alternative best suits or serves the purpose of common good or public good. Now, Hart agrees that the term public good or common good is very ambiguous or vague in nature and it has not been defined. But certainly there is a choice which is made, and the choice being that common good or public good may allow for sacrifice of principles like treating like individuals alike, treating like cases alike. Now, what Hart says here is, and this is where he brings the idea of distributive justice. And what Hart says is that whenever a choice is made without any prior consideration of interest of all sections of the community, it would be considered to be unjust. So, adding to Hart, what Hart is basically doing is, justice according to Hart is therefore not just about distribution or compensation and maintenance of proportionality, but it is also about taking into consideration interest of all sections of the community before coming to a specific decision. If interest of all section of community is not taken into consideration before coming to a specific decision, that specific decision may be criticized for being unjust or partisan. So what he is saying that, and this is an argument that he is making, that when we are making a choice between different kinds of claims, and when there seems to be a conflict between treating like cases alike with, let's say, greater or common good, what is important is that justice in this sense must also take into account the interest of all sections of the society before coming to a conclusion, before coming to a specific conclusion and saying that specific conclusion serves the common good of the society. And this is something and this is an aspect of distributive justice that he is talking about. So initially he was talking about justice in very simplified terms, that is justice as compensation, justice as a distribution of benefits and burden, but he also adds something more to this idea of justice and says that justice also talks about taking into consideration all the interest of all sections of community before coming to a specific conclusion, and therefore he says that This form of distributive justice differs from a very simplified version of justice which was discussed initially. And he concludes this segment of his discussion by saying that for here, what is justly distributed is not some special benefit among a class of claimants to it, but impartial attention to and consideration of competing claims to different benefits. So Hart is sort of bringing different aspects of justice into picture. The first aspect and the simplified aspect of justice that he brought into picture was that justice is about distribution of equitable distribution of benefits and burden, and it is also about compensation for any injury caused. But justice is also about impartial attention to and consideration of competing claims to different benefits. So you need to take into consideration all the competing claims and all the consideration of claims of all the sections of the society before coming to a specific decision. And this is how he is defining justice. So I think I'll stop here today because the next segment takes us to a completely different, not completely different, but in the next segment, Hart takes this understanding of justice to also define how there is a difference between moral and legal obligation. So the reason why he's making all this, introducing justice in the specific manner is in order to build up the argument in the second section of this chapter, wherein he tries to differentiate between moral and legal obligation. And therefore, the second section of this chapter starts with this argument that justice therefore constitutes just one segment of the morality. Justice cannot interchangeably be used with morality per se. It is just the principle of justice are not comprehensive in terms and do not exhaust all the ideas of morality, and there are different ideas of morality which may not fall in this concept of justice. Okay, I think I'll stop here, and if anyone has any question or has not understood some aspect of this chapter, they can ask. Or if it was too much and you want me to repeat something.
Hello ma'am, I have a question.
Yes.
So in the starting of the chapter, when he discussed about the necessary connection between law and morality, he quotes Thomas Aquinas, and the first contention of Thomas Aquinas, it is quoted over here that it is about discoverable by human reason and not with the aid of divine revelation. But it still says though they have a divine origin. So like so it's excluding the religious aspect from here, and also it's saying it might have a divine origin. So could you please elaborate on this?
Okay. So the natural law thinkers basically, when they are talking about certain principles of morality or justice which are discoverable by human reason, what they basically argue for is that there are certain principles, and especially Thomas Aquinas, that there are certain principles or certain principles of morality or justice which are universal in nature, in the sense that irrespective of where an individual is placed, by the exercise of human reason, that individual will be able to decipher the contents of those morality or justice. Now, why does he say without the aid of revelation, even though they have divine origin? Because natural law thinkers, at least as far as I remember, and maybe one of you, Haris, Sujit, or Ruchita, may correct me. Natural law thinkers, the initial stages of natural law philosophy believed in divine origin of law. There was a kind of divine origin given to law. And I think, as far as I can understand, Thomas Aquinas, though tried to break away from that tradition, he did not completely break away from that tradition per se. So, because a kind of divinity was, that's why this entire concept that there are certain inherent, individuals are born with certain kinds of inherent rights. certain kinds of inherent characteristic features of freedom. In the initial years of natural law philosophy, many of these discussions on natural law tried to ascribe these principles of morality or justice to divine origin. So, as far as I understand, perhaps Thomas Aquinas did believe in the value of human reason and human reason being used to discover certain aspects of morality of justice, but did not break away from the tradition of this divine origin. So that is how I understood, but I'm myself not perhaps very clear on how this entire evolution of natural law philosophy happened. So if one of you knows and can help me out here.